Hello, ladies and gentlemen. I am O'Brien McMahon, and this is People Business. In this episode, I'm joined by Dave Moore. Dave is a partner at Laner Muchin and the firm's Employment Litigation Department co-chair. While Dave spends much of his time defending employers in employment litigation of all shapes and sizes, his main focus over the course of his 20-year career as an employment lawyer is keeping employers out of the courtroom. On a daily basis, Dave advises business owners, executives, and human resources professionals on employment and labor law compliance, including on topics such as employee discipline and terminations, medical leaves and accommodations, wage and hour concerns, policy reviews and implementation, training, and on and on and on. Dave has been recognized among Illinois super lawyers and leading lawyers in 2024 and 2025. He was also recognized by the National Law Journal as an Elite Trailblazer in 2022 for his work with employers during the COVID-19 pandemic. I have known Dave for over a decade, probably the better part of 15 years now, and have always found his perspective and insights really valuable when it comes to the legal side of the human side of work. And I was excited to get him on the show here. I've not had an attorney on to cover labor and employment law specifically. I'll admit it's a topic that intimidates me a little bit just because compliance and the law are not a strength, but I thought it was finally time and really enjoyed the conversation with Dave. We get into a lot on accommodations in the ADA, but also specifically the emergence of the number of mental health accommodations that are showing up in the workplace right now. As he points out, we've always needed to accommodate for mental health, but just the volume has gotten higher and where we need to make accommodations versus where we don't. And we unpack that. It was a really interesting conversation. Talk about union avoidance strategies. We talk about really just how the human element shows up even in the legal side of work. I hope you enjoy this conversation. There's a bunch in here if you are a people leader to get out of it. I learned a ton. I found it interesting. I think you will too. Here is Dave Moore. Dave, welcome to the show. I've made it 5 years without touching on the legal HR topics, but it felt like time given everything that is going on in the world in 2025. And you and I have known each other for a long time. And so I appreciate you coming on and helping us through a topic that I will admit is one that I am not as strong on. So it should be an interesting conversation today.
Thanks for inviting me, O'Brien. Long-time listener, first-time caller for business. And most of my clients are happy when they go a decent amount of time without having to talk to me about labor and employment law.
Yeah.
It means they've been staying out of trouble or don't realize how much trouble they're in.
Every time I talk to you, I realize how much I don't know. And so I'm excited to record the conversation today and expand my own knowledge a little bit as well as help some others. Real quick, I know in the intro I've already read off your introduction, but how did you come to be doing the work that you do today?
Funny story. Before I went to law school, I had an inkling that I would enjoy labor and employment law. I was very fortunate as an undergrad student to work in the office of the general counsel at the university. And she would share stories with me about what types of matters or cases that she was working on and the matters that involved the faculty as employees were always the most interesting.
Just because they were the most crazy?
Yes. I don't know what that says about me, but it's just, I've always thought it would be an enjoyable experience. And also when I think about where I want to be, and when I was thinking about where I wanted to be, I wanted to specialize in a particular area. And so I wanted to find one that I would find enjoyment in and be able to help people.
Yeah. You deal with a lot of the messiness of people, so you landed in a good spot. So in your work as a labor and employment attorney, I know we're going to jump into some specific topics here today, but what are the issues that you see coming up the most? What are those repeat issues that, no matter who you are or where you are, you're going to face these if you're employing human beings?
There's so many. The first thing that would come to mind would be addressing medical issues in the workplace, whether it's impacting attendance or productivity or conduct. And mental health is just so much more prevalent these days. Most business owners, most HR professionals, they are going to have a number of employees from time to time where there are just a lot of mental health or physical medical issues that are making things difficult. Then, just on top of that, managing employees is difficult. Clearly communicating expectations and getting people to understand what those are and take responsibility for those expectations is difficult. Easier said than done.
Yeah. That topic has come up here ad nauseum on this show.
I know it has. I know it has.
So that's interesting. Let's just talk about that for a second, because it just occurred to me that we talk on the show so often about the importance of communications. It's important to set expectations and clarity so that the right things get done. It's important to communicate feedback appropriately so that you're building into your people. Communications help everybody feel connected to the mission and make you want to stay, improve tenure, all of that stuff. But like right off the bat, when it comes to legal, labor, and employment issues, making sure that you're good at the skill of communication, setting expectations, setting standards, giving feedback, that not only is it a good human practice, it's a good legal practice as well. Am I reading into that the right way?
Oh, absolutely. When I'm advising clients on difficult disciplinary or termination decisions where we want to understand the risk and mitigate the risk, the question at the end of the day is, can we explain to someone that doesn't know you, doesn't know anything about your business, doesn't know anything about this person, why it was fair that this adverse employment action was taken? And fairness starts with, were the expectations, were the rules, were the goals, were the objectives clearly communicated in advance?
So what are those best practices from a legal standpoint when it comes to communicating those expectations and setting them down so the person can understand them?
Yeah, there's different types of expectations. So there are conduct rules that hopefully are spelled out in your employee handbook, and hopefully you're onboarding folks with those. And then there's performance expectations. What do we expect out of this position? How many widgets are you supposed to produce a week? What sales goals are you supposed to hit? What project deadlines are you supposed to hit? And so you really want to let people know up front what the basic rules of the road are and what the basic issues are. And then you want to be timely when people are not meeting those expectations. So you want to start with some basic counseling or informal communications where you remind the person, this is the expectation, this is the rule, and here's how you're not meeting it. And that doesn't mean you need to have formal discipline or anything like that, but you do want to document, maybe in a follow-up email or just a note to yourself, that that happened. So be timely. Don't be shy about bringing concerns to someone's attention, because if we don't tell them that they're not meeting expectations, they may not realize it.
Yeah, so you hit on it there a little bit, but what does that documentation look like? What constitutes documentation that you could submit in a lawsuit if somebody sued you?
There's all different kinds. It could be just an informal counseling email. It could be notes that were taken during a regular one-on-one. Maybe you're meeting with your team on a monthly basis, and hopefully you're writing down the positive things that they accomplished, but also writing down where they weren't meeting expectations. It doesn't have to be overly formal. But then when things are not improving, you do want to move towards formal documentation, whether that's under the title of a disciplinary action or a performance improvement plan, or even just a performance evaluation itself. Because in most employment settings outside of situation where an employee is represented by a union and they have just cause rights, yes, it's at will. It doesn't have to necessarily be prior notice, but I go back to how are we going to explain this to a third party? And if you're building out documentation through the course of the issues, starting with informal emails, notes, doesn't have to be overly involved, then showing the documentation with formal warnings and reminding them, hey, we talked about this previously, this isn't new. And then ultimately, when you get to the termination decisions, there's different ways to document it, but those can all be exhibits when I'm defending a claim.
Okay. And that brings up a good point that I was going to ask anyway. And this is where I will first admit my naivete. Is my understanding is outside of union work for the most part, employment in the United States is at will. My understanding is like you could fire anybody at any time as long as it's not discrimination, as long as you're not firing them because they fall into a certain class. But if you don't like the way they show up dressed, or you don't like the attitude that they have towards your customers or towards you, that it is pretty easy here to sort of bring people in and out of organizations. But yet I know that we talk about this kind of documentation all the time. Help me understand, like, what is the basics? What are the rules around firing people who aren't fitting? Help me understand that a little bit, because I'll admit I get confused.
So everything you just said is correct. For
Okay.
most individuals in the United States, your relationship with your employer is at will, which means you can be fired or you can resign for any reason, no reason, with notice, without notice. But, and it's a big but, unless the termination would be unlawful. So, what are common examples of unlawful terminations? Taking an employment action based on someone's protected class, their race, age, sex, religion. Taking employment action because someone engaged in protected activity. They took job protected leave under the Family Medical Leave Act. They asked for an accommodation under the Americans with Disabilities Act. They reported a safety concern. They participated in a harassment investigation. They filed a workers' compensation claim. Most people at some point during their employment are going to fall into one of those groups. They're going to fall, we're all in a protected class. Many of us engage in protected activity at work because medical issue comes up with ourselves or with our family members. And so often when an individual is let go, they have a question in their mind, why me? This couldn't possibly be my fault. I'm a good worker. I met expectations. I feel like I'm being treated differently than my coworkers. And so a lot of people don't look inside and take responsibility for themselves. They look for a reason. They look for a basis to explain to themselves why this went wrong. And oftentimes they conclude that it's based on some protected class or protected status. And so that's why we want exhibit A, B, C, and D showing no, that this didn't have anything to do with the person's protected class or protected conduct. Instead, here's what we expected of this person. We told them what was expected. We told them when they weren't meeting the expectations. We gave them a fair opportunity to turn it around. And when they didn't, we had to move on. And here's the facts from the documentation that support all that.
Yeah. So what I'm hearing you say is you can fire people at will, but they also can sue you at will. And so in order to
That is
be
a very good way to
protected,
think about it.
yeah, in order to be protected and just be smart about what you're doing and CYA, these are some good steps to take. Make sure you document, make sure you're giving that feedback, make sure they have a clear understanding so that your third party, a potential judge or jury, would see that a reasonable person would understand that they were underperforming.
A lot of times with performance issues, they can be objective, meeting sales goals, things like that. Other times with conduct issues, it can be subjective. So You always want to make sure that you've done some investigation and got evidence to support your decision making as opposed to just feelings or suspicions. You obviously want to be consistent. Only reasonable. Does the punishment fit the crime? If you were talking to someone at dinner, would it sound fair? And then document and include those facts.
Yeah. Let's talk about ADA accommodations, because that's an offshoot of what we're talking about here as well. Because, like you said, people have, whether it's physical disabilities or whether it's dealing with mental health issues right now, which is becoming more and more prominent, there are accommodations that employers need to make. So, where's the line between employers needing to work out accommodations and not?
Unfortunately, there isn't a nice, clear line when it comes to accommodations. So, just to explain what I mean, under the Family and Medical Leave Act, this is the law that provides most employees in the United States with up to 12 weeks of paid time off. There are clear rules of the road as to how that works. There's specific forms, specific notice requirements, specific information has to be received from the doctor. And if the doctor provides it, well, there's some provisions or procedures for second opinions. It is what it is. The doctor fills out the form, the employee is entitled to the leave. The Americans with Disabilities Act is very different. The goal is to identify accommodations that will allow an individual with a medical issue to perform the essential functions of their job. And so every job is different. Every disability is different. Within the disabilities, how people are impacted is different. So you really have to handle those on a case by case basis. And then also, every job is different, every work location is different. So there are no bright line rules. Instead, what we're trying to do is have a conversation with the employee and with the employee's doctor, preferably through the employee, not directly with the doctor, to figure out, how do we make this work? What do you need?
And what does that conversation look like? Like, I've heard anecdotally, so the other side of our business, I work on the health and welfare benefit side of our business, but we have a commercial insurance side of our business too, work comp being one of those. And I have heard that employers who reach out to somebody like within 12 hours of them getting injured on the job are way less likely to see lawsuits coming in, because there's a human connection being made. There's some care being demonstrated, support and resources maybe being provided. In this type of thing, when it comes to accommodations, like, what are the best practices on a human level that help them connect with the employee and get to a good outcome, and maybe limit that employee's interest in getting combative or filing some kind of legal suit?
Sure. So you're right. There are going to be some situations, for example, a workplace injury, where the potential need for an accommodation is obvious. And that allows you to immediately open the conversation with the employee about, how can we help you? But the fact that someone has a disability, or that the disability is the cause of a performance issue, a conduct issue, a safety concern, it's not always clear. And so you start early on before it becomes obvious. If you're doing counseling, or you're doing discipline, or you're noticing an attendance issue, or someone mentions a medical condition, you can always just informally say, how can I help you? What do you need? So just going back to documenting counseling and performance, and every counseling email and every disciplinary action form, not necessarily with the question of, do you have a medical issue and how can we help you, but just, please feel free to reach out to HR or your supervisor if you need anything to meet this expectation. And then make sure that those types of outreach are put in writing. And Sometimes employees will open up, sometimes they don't, but it does remove the ability for the employee to have an excuse. It allows you to say, I've been asking you for 6 months. How can I help you? Why are we hearing about your medical condition when we're in the termination meeting? But then there are, like you said, there are going to be times when it's obvious. Somebody affirmatively tells you, I'm not able to submit my report by the end of the week because I had a flare up with my medical issue. I just didn't have time. I'm suffering from anxiety. The anxiety makes me irritable. That has something to do with why I've been lashing out against my coworkers. So when it's obvious, you can speak to the person right away and you can be more direct in your questions. So HR, not the supervisors, should lead this discussion. And you can be very direct in asking the employee to get specific information about what they need, how long they need it for, why they need it.
So you mentioned anxiety there. How is mental health covered under ADA today?
Yeah. So since I've been a practicing attorney for more than 20 years, it's been very clear that a mental health condition usually is a disability under the Americans with Disabilities Act. So that this is not something new, but certainly since the pandemic, the number of situations where employees are reporting that they are struggling with mental health is through the roof. And if I had to guess, I spend 20% of my time helping people work through these types of issues
Wow.
with employees. Yeah.
And so I guess my first question there is, what qualifies as a mental health issue?
If we're talking about the law, a disability is anything that impairs someone's ability to perform just a single major life activity, which could be walking, talking, sleeping, or working. And so when we think of mental health, often what the HR professionals are dealing with, depression, anxiety, bipolar disorders, things like that.
So I guess like bipolar, you can get diagnosed. I guess, do all of these have to be diagnosed? Do you need a doctor's note to say I have anxiety and it impacts my ability to do XYZ? Or are
Yeah,
we
so that's a
taking
great
people on their
question
word?
because in common parlance, you and I may be talking, and we're just my anxiety is out of control today.
Yeah.
Does that when I say that, does that mean I've spoken to a doctor or a therapist and they've diagnosed me with anxiety, or am I just saying I'm having a rough day at work?
Yeah. Because we
And so
all get anxious at some points in our lives. We all get a little depressed at some points in our lives. But that doesn't mean that we have a clinical issue going on. It just means life got a little sad or life got a little stressful. These are natural parts of our lives as well that we have to be able to come up with ways to get through. And yet,
right.
also, I want to be sensitive to the fact that these are also debilitating issues for some people. So, how do we draw that line when it comes to making legal accommodations in the workplace?
First, we don't play doctor. Instead, we issue written requests to the employee to obtain medical opinions from their treating healthcare providers. And there's certain information you can ask for, certain information you can't. But in a baseline where we can draw a line is if an employee does not submit supporting medical documentation that shows that they have a disability and that they need accommodations of that disability, then they don't have rights to accommodations under this law. They're not going to be protected under this law. It's a two-way street. If they are not proactive in obtaining the information from their treating healthcare provider, then we're not going to have an obligation to accommodate them.
I think that's helpful to draw the line in how we get a doctor's note or medical evidence that these things are real. But there's also a line where persistent issues could be impacting their ability to actually do the work, even with accommodation. And like you had mentioned earlier, somebody has anxiety and that's why they're behaving a certain way that is having a negative impact. Okay, if that flares up and that's happening this week, okay, we can deal with that. We can work around that stuff. If that happens every week, now we have a problem. And now it is impacting somebody, the whole team, all of our ability to do work. So, how do we think about that? Is there a line where we're making accommodations, but the person's mental health issue is still such a problem that it is impacting their ability to do the work with those accommodations? And so we then have the ability to terminate them? Like, I imagine that we're getting at a really sensitive ground here. So, what do those conversations start to look like?
So, just to take a step back, to put yourself in the position to have those conversations, assuming we receive a medical certification from the doctor, it's going to identify a number of accommodations that the doctor recommends. And so then you want to sit down as the HR professional with the supervisor to review them, see what may work. Then you want to sit down with the employee and talk about what will work. And hopefully, we can approve a number of the accommodations requested by the doctor, but we should be creative. If there's something that the doctor asks for that, for whatever reason, we can't agree to, maybe there's something else that we could offer that we've thought of, or maybe we could ask the employee if there's something else, so that we are, in fact, in good faith, trying to give the employee the tools that they need to succeed by way of accommodation. But that doesn't shield the employee from our performance expectations, doesn't shield the employee from the conduct expectations. And so if we've had gone through what we call the interactive process under the ADA, and we've listened to what the doctor had to say, what the employee has to say, and then we've said, here's what we can do for you in writing in terms of an accommodation plan, and lived up to it, then it's up to the employee, in my opinion, to sink or swim. We're trying to give them what they need to swim and be successful. But if they're still not meeting expectations, then as long as the expectation has been brought to their attention in advance and we've told them why they're not meeting it, and we've given them an opportunity to turn it around. If they haven't turned it around, then we can move forward with the appropriate proportional level of discipline.
How do you help clients get comfortable with the fear of retaliation? Because that last part sounds great. And we could get there and we can feel really good that we've done everything that we need to do. We really care for our people as a company and we really try, but we're just afraid. Some of these people have voiced threats maybe about suing, or they seem like the type who might be a little bit more confrontational. And there's just a fear. And so we don't take action. How do you help your clients cope with that fear and feel comfortable that they've done everything that they need to do?
And so there's always going to be a concern when you terminate an employee that they may file a claim. And with medical issues, oftentimes the individual situation is very sympathetic. And so there is a hesitancy about taking action and holding people accountable. But there's things that we can control and things that we can't control. And I often tell employers that in these types of situations, it's always going to be messy. There's always going to be risk. There's never going to be a perfect time to do something. So when you're looking at the situations, just go back to, if this person's really not meeting expectations, can we explain to someone else why the disciplinary action or the termination decision was fair? Can we explain what we did to try to help them succeed? And can we show why they didn't succeed, either because they weren't trying or they were trying their best, but they couldn't? So the key is just, can we explain this to a neutral third party in a way that's fair? And then you always have the option of thinking about offering severance.
One other question that kind of pops into my head as you're saying this, we were talking a little bit before we hit record about recent guest Cash Nickerson, who came on to talk about the 7 tensions of negotiation. And one of the things that I brought up with him is, what if you're one of those people that just, you're going to fold in a negotiation? Like, you don't like conflict. When there's pushback, you have a tendency to give in. I was leading a session at work the other day about setting boundaries, and somebody asked this question. I just know if a client comes and they just really push hard enough that I'm going to cave and do what they ask me to do. Is there guidance that you have for how companies, HR teams, leadership teams, managers can use their attorneys, either inside or outside counsel, as an agent? Like when we think about agency tension that Cash was talking about, to step in so that you don't cave and you don't give that person another chance after you've given them 5 other chances. Is there a way or a best practice for using legal counsel in that capacity?
Yes. So I think that when a supervisor or whoever it is, that's the person that would have to take the action, meet with the person, explain to them what's going on. They're a timid person or they're just very nice and they want to avoid conflict. That's stressful. These are uncomfortable situations. So, how can an outside attorney help? Often, just being able to talk to us in an attorney client privilege setting allows people to be a little bit more loose and comfortable with what they have to say. It allows them to express themselves, their concerns about the situation, the concerns. Am I doing something wrong? Am I setting myself up for risk? Am I setting the company up for risk? And then the attorney can hopefully explain, here's what the risk factors are. Here's why your feelings about this employee are reasonable. Here's how we can help you script out conversation. Here's how you go about talking to this person. Do you need help with talking points? Here's how we can write those out. Do you want to rehearse? Here's how we can help you document it. So we can really help facilitate and coach individuals through those very uncomfortable situations.
Yeah. Well, that's good. I think that's helpful. Do you have a role play with clients?
Yes. But it's often me putting the hat on of the plaintiff's lawyer and asking them to respond to what's going to be coming at them in a risky situation.
Yeah. I could even see doing that if there was somebody that they were worried about terminating, and what could this person say, and what if they push back too hard, and that kind of role play can be very helpful. Role play, I'll admit, is one of the most uncomfortable things that you can do in an interpersonal interaction. I've felt it. I've role played with other people and seen them squirm and feel it, but it is amazing when you force yourself to do it, how much easier it makes that actual interaction. That, I mean, just
Right,
every time.
because I think that's you get used to that stress or that skirmish. To me, it's just like practicing a speech in front of a mirror. Once you can get those first few lines out while looking at yourself, you can get a lot more comfortable.
Yeah. Yeah. And there's a weird thing with role playing where most people find it to be more difficult to role play than to actually sit through the experience. I don't know why that is necessarily. It should be a safer environment, but there is something about the fact that it is so hard to role play and hear yourself practice the words, that when you get into game time, when you're actually sitting down, they just flow so much more naturally.
Absolutely.
Yeah. All right, let's move on a little bit from that topic. Another topic that is timely now, but I mean, it's been around for a little while at this point, and it doesn't seem to be going anywhere, is this concept of where we do our work. Are we in the office? Are we hybrid? Are we fully remote? What are the legal issues that you see companies dealing with when it comes to setting these policies? Like, where are companies tripping over themselves, and what are some best practices for thinking about setting this kind of policy?
Sure. So, where employers often stumble is by saying we don't allow a hybrid workplace or remote work, period. And therefore, we're not going to accommodate your medical issue
Got it.
by considering a hybrid work arrangement or a remote work arrangement. But decades before the pandemic, EEOC guidance was that remote work may be an accommodation. So even if you are a company that by and large doesn't allow remote work, you may still have to in certain situations. But otherwise, beyond that, the employer is in the driver's seat in terms of determining what the or where the workplace is going to be. I'm old school. I'm a big fan of collaborating in person, mentoring and training in person, building relationships in person, but that doesn't necessarily reflect the realities for recruiting
Yep.
today and retaining employees today. So I do think it is good to have a written policy. It should explain that this is a privilege. It's not a right. Need to think through, are all positions at our place of employment up to be remote or hybrid, or are there only certain positions or units that would be eligible? Who's going to make the decisions? What is the approval process? Does it get submitted to HR? Does it get submitted to supervisor? Who has to sign off on it? Then there needs to be clear communications about when the employee is going to work at home and that they need to have themselves available to communicate. I think it's also important to establish regular communication between the supervisor and the remote worker. If you haven't communicated with someone you supervise for a couple of weeks, you may start to wonder, what are they working on? You can eliminate that by having regular one-on-ones with them.
Yeah. And that's a best practice that's been brought up on this by remote work experts anyway, is the way that you lead a remote team needs to be a little bit different, needs to be a little bit more thoughtful, because you're not having those serendipitous interactions all the time.
Other things to think about, obviously we want to hold people to productivity expectations. We want to be clear with employees about secondary employment. We want to be clear with them that they shouldn't have a lot of privacy expectations on our laptop. We want to be thinking about expenses. Who's paying for cellular service? Who's paying for Wi-Fi? Do we have an obligation to provide an ergonomic chair? Also want to be thinking about, how are we tracking hours worked for payroll purposes and overtime purposes?
Okay. You brought up one issue there, and I had another. So what I heard you say is the big issue there is accommodation, and making sure that as you're setting policy, that doesn't tip back into our prior conversation around the ADA and accommodations that we need to make. But I've seen a rise of two phenomenon. One is they let people work remotely. They hire somebody who, you and I are both sitting in Chicago, Illinois, and 4 months later, suddenly that person shows up in Billings, Montana, where they don't have any employees. And it's, wait, how'd you get to Billings, Montana? Or they show up in like the Virgin Islands for 6 months. And it's, wait a minute, we're not set up for the tax implications of that. So I've seen that. And then I've heard more of the rise of people working dual jobs. So let's start with the first one, with relocations. What can employers do, or what should they do when that kind of thing happens, where somebody just shows up in a new state and now suddenly they're burdened with the tax implications or with other administrative or legal implications of that? How can they get ahead of those issues?
Yeah, so I think it starts with your written policy. So I do think that you want to be clear that the approval for remote work is based on them working from their current home. And then when you go through the approval process, you want to set the expectation that if they are considering moving, they have to tell us, because you hit the nail on the head. It can have all kinds of income tax consequences that you may not be prepared for, and all kinds of employment law compliance issues, whether it's state income tax, unemployment laws, workers' comp laws, but just these ever-changing paid leave laws. And so if employees are moving around without speaking to you in advance about it, and you've told them they're not supposed to, that may be a reason to end their employment. Not that I want anyone to get fired for moving to Billings. It's a lovely place.
Yeah. Yes. Okay, that's good advice. What about the second one, when people get caught working two jobs?
Right. I think you had someone on your podcast recently that said that it was to the effect of you can't have a side hustle and still be good at your regular job. And so a lot of employers have secondary employment policies. You do want to make sure that if you are going to prohibit secondary employment, that you've set up those guidelines. You've also set up the rules for when it will be approved. But if someone is supposed to be working for you during the regular workday and be available, and you learn that instead they've started a side hustle, they're working for someone else, and they're using your equipment and your time for those endeavors, you don't have to put up with that.
Okay. But just be clear in the policy up front around where you live, who you work for, who you're allowed to work for. That's a good point that you made. It feels like there's a difference between somebody who works for XYZ Corporation and ABC Corporation. But more and more people are working for XYZ Corporation and themselves. And they have some online business or some coaching business or some consulting business or something like that. I have a tendency to be like, oh, well, that would be a different category, but it doesn't necessarily need to be. And it's just how you set your policy. So you can set policy that people are not allowed to have side hustles. Like, how would you actually set that up?
So there's all different ways to set up the policy. An employer could say no secondary employment of any kind without permission. That doesn't make a lot of sense for most employers. So then the next way to think about it is no secondary employment if either one, it interferes with when you're supposed to be working for us, it interferes with your schedule. Two, it interferes with your productivity. Or three, it's in a business that's a direct competitor of ours. So those are what the policies usually look like. Is it going to interfere with your availability? Is it going to interfere with your productivity? Or is it going to create a conflict of interest? And so you set that up in the policy, and then you set up the approval process for being allowed to do it. In some employers, there is no approval process. If you're following those three rules, it's okay. In more regulated industries, there may be reasons why you can't have any secondary employment without permission.
Yeah. And that follows through, like, we have within Lockton a registered broker dealer. So there's a lot of legal requirements about the investments that we can make, the type of private investments that we can make. And so that to me is kind of a similar offshoot. There are certain reasons why you wouldn't be able to do certain business activities, and you just need to make sure that you're setting those policies appropriately. Okay. Switching gears, another topic that has come up a bunch lately is the topic of unionization. And I've had several clients who have had pushes for unionization. I was in a meeting just earlier this week, and they were saying that there are some whispers of organizing activity going on at their facility. This is another area where I don't fully understand the law and am interested to learn from you. What is an employer allowed to do when they find out that there are employees talking about unionizing? What are the avoidance strategies that are illegal, and where do we then tip over the line into something that would be illegal?
So we could talk about this subject for hours. If you're already at the point where you are hearing that your employees are openly discussing organizing a union for representation, you're really in a bad place.
Okay.
So you need to be thinking more proactively. Baseline as an employer, you want to be kind, you want to be respectful, you want to be fair. But in our experience, it's often not concerns about specific wage rates or benefits that drive employees towards a union. It's often a manager or a supervisor who is a jerk or a bully, and people hate and they are just sick of this person. And so, some of the proactive steps that you can take, which are entirely lawful, are labor relations audits. And those can take many different shapes and sizes. It could be attorneys interviewing your employees to see if they have concerns about anyone. It could be 360 reviews, which you often think of more in a white collar setting, but there's no reason that can't occur in a blue collar setting. So if you have supervisors and managers that you know are not treating employees with respect, you are asking for one of them to get upset and to contact a union. And
Well,
then
that, just to interrupt there, that makes the case for investing in leadership development down the chain within an organization, because we've talked about it on the show a lot. I've talked about it with companies that I interact with in my work a lot, is you do a lot of coaching at the executive level, or maybe the senior VP, maybe even the VP level. But when you talk about blue collar work, a lot of companies are not developing the frontline leaders who are stepping up to take on supervisory roles, manager roles. Like, those people are largely still ignored when it comes to developing the interpersonal skills. But I've had somebody on here before talking about how to improve low wage work and low wage retention, and it was manager training at the lowest levels. And so it's interesting to hear you come in from the legal side and say, train your people to be good people leaders at the lowest levels.
that's right. And so this would help you with labor relations concerns, but that additional leadership and training and development, that's also going to help you minimize overall employment law risk.
Yeah. And by the way, I just said lowest levels, and I realized that sounded bad to me on the way out. So just because somebody is a frontline blue collar manager doesn't mean they're a low level. I just want to be like clear on that. Lower income levels, because we tend to, the lower the income goes, we tend to ignore those people. So I just wanted to clarify that, because as I said it, I was like, ooh, that doesn't sound great. So apologies to anybody who heard that the wrong way. Any other best practices when it comes to getting ahead of unionizing efforts?
Again, the labor relations audits and investigations, but then when you do hear those whispers, more likely than not, there's a lot more going on behind the scenes than you may hear employees talking about it. And that could mean that a union business representative is already out collecting signatures in favor of a union. They may already have close to majority support, and you may not know it. And so once the union goes to the National Labor Relations Board and files the petition to certify a union, the timeline is very short. The rules of the road are very specific, sometimes counterintuitive, and can be really difficult to navigate. And so you really need a labor relations professional to guide you through that. There are so many things you can say, so many things you can't say. And so it is a treacherous path, and it all occurs in a very short amount of time.
That's helpful. And it is interesting to hear you say that if you're hearing those rumblings, you're already a little bit behind the eight ball. And so I guess if you are starting to hear those rumblings, is the advice then to start to, I guess it's never too late to do the human to human stuff and invite some managers in to be developed, ask for 360 feedback, go out and do a listening tour of a facility and hear what's going on. Like those types of interpersonal things, as we touched on earlier, they go a long way into building relationships and building trust. So it seems don't shy away from that stuff, even if you feel like maybe you caught it a little too late.
So when you're just hearing the whispers, as opposed to a union has filed paperwork with the NLRB for an election, when it's just whispers, you still have a lot of license to ask questions. Hey, what can we do to make this a better place to work? What are the things that you think that we need to improve upon? How can we make this work satisfying for you? Are there things that are happening here that you don't think are fair? But as soon as that petition gets filed with the NLRB, then there are very specific rules of the road that you will need professional help navigating.
Okay. Yeah. Because then some of those same activities could be viewed as
Unlawful interrogation, unlawful intimidation, direct dealing, all kinds of things that are problematic during a union organizing campaign and counter campaign.
Got it. And as you said, this is a much broader topic than we have time to cover in the last few minutes here. So I think that is good advice. If the paperwork's been filed, talk to your attorney and get legal help or reach out to Dave. Yeah. But if you're just hearing the whispers or if you're seeing news articles and you want to make sure that you're getting out ahead of it, all the human relations stuff is still on the table.
And obviously, avoid threatening people for engaging in their protected conservative rights.
Let's just avoid threatening people at all in the workplace. I think that's probably a best practice.
Good rule of thumb.
Legal or otherwise.
Words to live by.
Yes. Yes. I struggle with that most as a parent, where I threaten to take away television or dessert a little too often. My wife, that's where I'm working on not threatening people. Good reminder here that legal or not, it's never a good idea. I know we're almost out of time. I did want to just touch, there is so much happening in Washington right now while we are recording this. Trump came in with his flood the zone strategy. He's issued hundreds of executive orders. We've got some tariff chaos going on. I don't necessarily like to react to what was said or happened today specifically, because Lord knows how that'll change tomorrow. But are there changes that you are seeing that are looking like they're going to be more sustained coming out of Washington that employers need to be paying attention to in the coming days, weeks, months, years?
On a positive note for employers, as opposed to maybe employees, it seems much more likely that enforcement initiatives by the U.S. Department of Labor, by the National Labor Relations Board, will be lessened and more targeted. So that is certainly positive for employers. We expect more of a focus on voluntary compliance as opposed to enforcement through penalties and litigation. So that's something that I think is likely to take hold. We're still waiting to see what comes of immigration enforcement. When the new administration first came into place, the concern of the day was, what do we do if someone from ICE shows up at our door? And we're not actually seeing that so far. Maybe by the time this podcast airs, we will see more of that. But what we're seeing is really, this may be anecdotal, but what we're seeing with our clients when it comes to investigations by ICE, they're usually targeted at individuals that ICE believes are removable for a particular reason, maybe because of involvement in a crime. But we're not seeing mass raids or anything like that just yet. I do think that there's going to be a change in the way we talk about training in the context of diversity, equity, inclusion. think we're going to see a lot less of that terminology, but whether the law actually changes there is to be seen. The EEO laws still prohibit discrimination and harassment based on protected classes. These laws have never permitted preferential hiring or promotion. And I think most DE&I programs, that's not what it's been about. And the EEOC has started to define what it views as unlawful DE&I programs. But when you look at their guidance, so far at least, they're really restating what the law already is. If a DE&I program provides preferential treatment or takes an adverse employment action against someone in whole or in part based on a protected class, that's unlawful. That's not new.
Okay. Yeah, and we had our head of government relations from Lockton speaking at a dinner that I hosted a couple weeks ago, and one of the things that he reminded everybody is that just because something comes out in executive order does not mean that it is law, and that there is often a long time before those things get codified, if they ever do get codified. And the point that he made that I thought was really interesting is there are very real repercussions coming out of Washington, especially around DEI, when it relates to organizations that get government funding. So we're seeing it, we just saw with Northwestern here in Chicago with higher ed. We're seeing it in healthcare, nonprofits, those types of organizations that get direct funding or grants. But for general industry, we're still waiting to see what it means. I think that was good advice for me, just whatever the topic, whether it's this topic or anything else, because this administration and maybe future administrations will do this too, because there's such a flurry of activity that it's, oh my God, what do we have to do right now? It's like a lot of times the answer is we don't have to do anything right now. Let's just start paying a little bit more attention as this thing plays out. And so I turn the temperature down a little bit on some of this stuff for most people.
Yeah, I think that's right. After the first quarter of this year, what do we know in this overall area? We know that federal contractors and federal grantees do have some very specific changes. So if you're a federal contractor, your affirmative action plan obligations have changed. You still have an obligation to have these plans, but it's only for veterans and disabled individuals. It can't be based on other protected classes. And then federal contractors and federal grantees are being required to put language into their contracts with the US government that explain that or certify that they do not have any unlawful DE&I programs, but there's no statute that defines what DE&I is yet, to your point.
Yeah.
As you're thinking about your programs this year, focus on merit and not background in employment decisions. Obviously, don't have quotas, don't offer bonuses based on achievements in diversity in hiring or for hiring protected classes. Give equal access to training, equal access to networking. If you're having training programs, don't criticize particular demographic groups. Just focus on being respectful of all of them. And if people have objections to your program, listen to their objections. Maybe they have a valid religious objection for participating. But folks should start reviewing their policies, their training, and their public statements. If you wanted to be risk averse, maybe stay away from characterizing things as DE&I. Maybe focus on language that's about offering equal opportunities for everyone and looking at merit for when making decisions.
Yeah. A welcoming workforce instead of an inclusive one.
Unfortunately, I think some employers do need to think about recasting the language, but ultimately the substance is based on equal opportunity, not equal results.
Yeah.
And it's focused on merit. And then I think you're going to be fine.
Yeah. And I do think, to be fair to one group of this, like I have seen programs that are billed as inclusive that are not inclusive, that make one group feel bad versus another group. And so I never thought those were a good idea anyway. And it is a good idea to cut those out. But most of what
Right. And
falls into this category.
that's not new. There are some older cases that predate the current administration where people went way too far in one direction or another, and courts held that was unlawful harassment.
Yeah. Dave, this is fantastic. You delivered because I did learn a ton during this. So I really appreciate it. I'm sure other people will learn a bunch too. Is there anything that we didn't talk about that you are like, hey, this is really important? I just want to make sure we say this before we sign off, or any final thoughts that you have?
Not to keep repeating my mantra, but if you're looking to minimize legal risk with your employees, best rule of thumb is just be as fair and kind and respectful as you can. And if you're focused on that, you're usually going to stay out of trouble.
Yeah. Well, I love that that's the theme that came out of this. I was not expecting that at all, but I think to have covered a legal and compliance topic and hear that the feedback is just be a good person and treat other people well, and you'll get pretty much all the way there. That's a comforting thought.
Yeah, and obviously there's areas where there is real technical compliance and
Sure.
knowledge required, like wage and hour issues and benefit plans, things like that. But when it comes to the employee relations issues, it really is about how do you show that what we're doing is fair?
Yes, there are technical things that need to be done and steps that need to be followed. But even in those, when you're planning them, if you are planning them thinking about the people you're planning them for and trying to be fair and reasonable to those people, oftentimes that can mitigate issues too, assuming you then also are following the steps you need to follow from a compliance standpoint. But Dave, this is great. I really appreciate it. Appreciate you. Thank you for all the knowledge here and over the years. And for anybody who is listening to this, who's like, yeah, we need some help with all of that. This is what Dave does professionally. So I want to plug him on that. He is working with clients every day on these issues. So feel free to reach out to me through the podcast website and I can connect you with Dave, or feel free to reach out to Dave through LinkedIn. And I know he's always happy to help solve these issues. So just want to make sure we wrap up there. But Dave, thank you. Everybody listening, thank you. And until next time, good luck navigating your people issues.
Thanks, O'Brien.
Hey folks, one last thing before you go. If you enjoyed the episode, make sure to hit subscribe so you can stay up to date with future guests. That's it. Thanks for coming. Go make the most of your business and the people in it.